Part 10, context. This is the direct appeal right after I was convicted and sentenced unjustly. This is the appeal concerning my sentence that my public defender, who was the same one that represented me at the jury trial, this is what he argued about my sentence, y'all. Pay attention. Argument 2, appropriateness of the sentences. Martin refused to cooperate in the preparation of a pre-sentence investigation report. The trial court relied upon the information submitted by the state at sentencing and made numerous references to that information in the sentencing order. The trial court found the nature of the offenses, the character of the offender was indicated by his criminal history as aggravating circumstances. Remember that. The trial court believed it was important that there be a separate sentence for each attempted murder conviction and consequently ordered the 4 enhanced 40-year sentences to be served consecutively for a total sentence of 160 years on those convictions. The court imposed, for all practical purposes, a life sentence. Martin contends that a life sentence is inappropriate. A more appropriate sentence for the convictions on these charges would be 65 years. That is the maximum sentence for murder. Conclusion. That's it. That was the grand argument, y'all. Conclusion. Wherefore, the appellant/defendant, Dante Martin, prayed that his convictions for attempted murder be reversed for the reason of insufficient evidence. He further prays that his sentences be modified and reduced, and for all other just and proper relief. Jeffrey Rath, the public defender, word count certificate. I certify that this brief contains no more than 14,000 words. Signed by Jeffrey Rath, the public defender. So I want y'all to pay attention to something. To argue my sentence, I'm your client, I'm his client, and I was just sentenced to life in prison. In all actuality, 170 years. So if you're arguing against this life sentence that I just received, I want you to understand what he did. This is all he argued, one paragraph, about a person that just received 170 years in prison, a 170-year sentence. This is all he basically said. Martin contends that a life sentence is inappropriate. A more appropriate sentence for the convictions on these charges would be 65 years. That is the maximum sentence for murder. So, I got 170 years, and all you say is that the sentence is inappropriate. A more appropriate sentence would be 65 years. You give no explanation. You cite no case law, nothing to support that position that 65 years is more appropriate, or that it's a more appropriate sentence. That for all practical purposes, it's a life sentence. Like, you show no fight, no argument. This is the 2 lines. These are the grand lines right here. When it comes to my sentence, this is the argument for the appropriateness of the sentences. A more appropriate sentence for the conviction of these charges would be 65 years. That is the maximum sentence for murder. Conclusion. Nothing further. Anybody that's a lawyer out there or a paralegal that got any type of sense, if you go to Notre Dame Law School, IU, Bloomington, if you're in Indiana, anywhere, if I just read you this, and this is the brief, this is a real brief from my public defender. If you think that there's something wrong with that, attacking the sentence of someone that has basically a life sentence, 170 years, who's innocent of the charges, number one. And this is the argument for somebody that has life in prison. This is what my public defender did. So that is the end of this brief for y'all to know. SubhanAllah. This is nothing but the judgment of conviction. So this is not a part of the appeal. This is what happened when they sentenced me in the court. So as you're going to see all my charges right here. But I will note this. When they're supposed to identify on the judgment of conviction, they were supposed to identify that the following circumstances are aggravating/mitigating circumstances. They left that blank. So they didn't identify the aggravators or the so-called mitigators, the so-called aggravators and the no mitigator that the judge said weren't there. They didn't identify them on the judgment of conviction. So that's the end of that brief. Next, what I'm going to read y'all is the red brief. I'm going to focus on the sentencing out of this brief. As I told y'all earlier, blue brief, my public defender. This is supposed to be my fighting. This is my weapon right here. This is my fight, my defense on my behalf, my argument to support me on my direct appeal. This is what the public defender that they assigned me gave me. Red, comes from the prosecutor. This comes from the state of Indiana. This is the deputy attorney general. He does the red, which is basically he explains the reasons why he feel my conviction and my sentence are appropriate. They're not against the law. So I'll read from here, and I'll be reading. I'm going to stick straight to the sentencing part. I'm going to get to it, y'all. Inshallah, we're going to get to it. After I read this, then I'm going to read the court of the decision. We're going to focus on that sentence. We're going to see what it's about, y'all. I appreciate y'all rocking with me. Inshallah, we're going to get back with y'all. That's part 10 of the blue brief. And now I'm complete. When I get back with y'all, I'm going to be on the red, inshallah. Assalamu alaikum wa rahmatullahi wa barakatuh. To the rest of the world, peace. Appreciate the support, y'all. Alhamdulillah.